Good morning, folks. We're going to give it just another minute or two before we get started. We're waiting for the room to fill up. We've got nearly 100 people in the waiting room right now, and I think we have over 450 people registered for today. So just give it a few more minutes, and we'll get going. Get yourself a cup of coffee, or a second cup, or a third cup. We'll be with you in a minute. Well, good morning, folks. It's 8:02, and we're going to get the program started here. We've got about 150 people in the program right now, but we've got a couple hundred more. So I'm sure they'll join us. But in the meantime, I want to get things started. You've got a busy day. Welcome. This is New Hampshire Tech Alliance HR Exchange. My name is Jim Reedy, and we're coming to you from our host, Chi and Finney. And today's topic is discipline and termination tips from the trenches. That's quite a mouthful, but it's an important topic. And in fact, off camera, we were just talking about that and saying that, in the day-to-day of HR, this is unfortunately an important topic, something that every HR professional has to deal with at some point, some more often than others. But it's important. And in this legal climate, in our just effectively with the changes in the law and our culture and the like over the last, say, generation, it becomes more commonplace to have legal issues arising. And certainly with the multiplicity of laws, there's a lot to consider with discipline and discharge. Apart from that, of course, you've got issues with your organization, you've got financial issues with individuals and the like, and just a lot in the mix. And I'm just thrilled that my colleague Karen Whitley can be here today, experienced employment lawyer, someone that many of you know and deal with on a regular basis, and here to talk about that. But in the meantime, just want to give you a preview of what's coming up with our next couple of events. Next month, we've got on April 9th, managing leave and attendance with federal and state leave law issues, and that's Jen Meckel is going to be talking about that. And likewise, over the last, say, 10, 15, 20 years, an explosion in leave laws, not just the FMLA, but many state leave laws, and now parental leave laws and the like. And many of you have operations in more than New Hampshire, and states beyond New Hampshire. And so with that, a lot of things to consider as you look to not only comply with those statutes, but work with your employees to understand their leave rights and obligations. So that's April 9th. Then in May, we don't have a Tech Alliance event because that's a very popular month for HR events, including, which I'll talk about in a second, our May employment law seminar. That's okay. Quick to the trigger there. I like that.
I did.
And then June, we just do our year wrap up, which is employment law and review. And that's sort of end of the um, calendar year for purposes of what the Supreme Court might be ruling on, but also what's happening in the legislative side of things and so on. But then let's go back to the May event. That is I can't believe it, our 37th annual employment law seminar. It's the Castleton Resort in Wyndham. You see the topics there. We have our entire employment group and others speaking at this event. You can see the topics. It's everything from wage and hour to the National Labor Relations Act, state leave laws, AI issues, workplace violence, preparedness, non-discrimination, hiring and compensation, and harassment. And it's just a great opportunity for HR professionals to be together. That room has capacity for about 300 people. We already have, it's amazing. It's what, March 12th. We already have over 220 people registered for that event. So if you haven't registered yet, we encourage you to do so. Again, our capacity is about 290 to 300. And it promises to be a terrific event. We've got a few surprises in addition to what's in that agenda. So if you haven't done so, we encourage you to do so, and you can find that information on the She Infinity website. Now back to the topic. One other housekeeping matter. I'm sorry. At the end of this program, for those that are familiar with us, you know what's coming next. That is an email later today from Liz Tezik and our marketing group that will send you a copy of the program, a recording of the program, and the SHRM code for attendance today. It's also at the very end it's one of the last slides that we deal with today, but it's all in a package, neatly wrapped and tied in a bow for you. So back to the topic. I am just so thrilled that Karen Whitley could be with us to talk about this important topic, dealing with discipline and discharge of employees and all the many issues of both policy and legal issues that you deal with. And so with that, I'm going to turn it over to you, Karen. Thank you all for being
Good morning, everybody. Thank you, Jim. So I'm going to be talking about discipline and termination. And this is something that we deal with employers on almost a weekly basis. And over the past several months, there's definitely been an uptick in this. And I often find that the employers will call and, have an immediate need and need to sort of condense all of what I'm about to tell you in, a phone call and then maybe another call the next day before they terminate an employee. So I applaud you for being proactive. Hopefully for many of you, there will be pieces of this that you've had to deal with. And hopefully you have a chance now to dig in a little bit and see sort of why these things are important, and are there some additional steps you can be taking to make sure that your discipline and termination process goes as smoothly as possible with, I guess, minimizing the risk as much as possible from a legal standpoint. So I like to break these things up into some bite-sized pieces. So we're going to first talk about setting yourself up for success when you're dealing with discipline and termination issues, the decision-making process, double checking and the importance of double checking your decision-making process, documenting the discipline and termination or termination, implementing it, and the messaging. So let's dive right in. So setting up for success. Again, this has a couple of different segments. We're going to look for clarity in a whole bunch of different aspects in order to be successful. The communication, consistency, and collaboration. So in order to set yourself up to have a successful discipline process and or termination process, you're going to want to make sure that the expectations are clear. So employees should be aware of the policies that you have. And I've listed here a couple of or several of the policies that are most often the basis for discipline or disciplinary discharge, the more serious ones. But as we'll get through this, obviously discipline comes in many forms as a result of many different things that could happen in a workplace. But you're going to want to make sure that you have clear policies about discrimination, harassment, and retaliation, about attendance expectations, and about various types of misconduct, which could include theft, weapons, other misconduct, which could be gambling, reviewing pornography, the more serious stuff. But then generally about job expectations. You want to make sure that you're as clear as possible about all of that. And those expectations can be set out in a job description, for this is what your job entails. This is what we expect of you. This is what you're supposed to be able to do from, a variety of standpoints, physical, mental, focus, concentration. These are the types of things we expect of you. So to be as clear as possible about that in a job description is a very good first step. And then, of course, your handbook, which is obviously not a contract. It confirms that the individual is still an at-will employee, regardless of what's set out in the handbook. But that handbook really is a key place for an employer to be clear about what its culture is, what its expectations are, where the tolerance is for various types of conduct. So it's a really important place to focus. And I'll just say, and then of course, standalone policies and memos that can supplement or be in the place of a handbook. So I was in a mediation last week, and a job description was absolutely picked apart by the mediator because it was not clear and it did not give the employee or the argument was that it did not give the employee sufficient information about what the job was. And obviously, when you're involved in a Commission for Human Rights or EEOC, or even litigation on discrimination, harassment, and retaliation matters, a handbook is often one of the things that those agencies will ask for. So being very clear in those documents can be a really important first step for setting the stage for some form of discipline. If you're going to base discipline on poor performance, on a policy violation, you really have to make sure that the employee understands what that looks like. So this is the time of year where a lot of employers are reaching out for handbook reviews just to make sure they're up to date. But it's never a bad idea to have somebody take a fresh look at the policy and say, is this clear enough? We just had this other situation. Was it addressed here? Could it have been addressed better? So be clear about also how employees can bring their issues to HR and management. So they may understand what the expectations are of them, but they might not know what to do if they see inappropriate conduct by someone else, if there's conflicts with other folks. And so having a clear path forward for them to contact HR. Who do they contact? How can they do that? Can they go to their manager or supervisor? Who else might be available to take action if they feel something's going wrong? And with a clear path like that, with clear communication about how to go forward and who to contact, you might be able to stop some disciplinary issues early in their tracks, as opposed to waiting until something egregious happens. So making sure that you are clear about that is again another very good step. And what to do if an employee themselves is having some disability issues that might affect their performance or their attendance. You don't want to come down very hard on someone who is having some new attendance issues or some new performance issues and not have given them an opportunity to come forward to you first to say, I'm struggling because I can't sleep at night, so I'm tired during the day, or whatever the disability issue may be. So again, being clear about that course of action. Which goes hand in hand with being transparent about what your leaves of absence are, what your policies are, and the process that somebody would have to use to take advantage of a leave of absence. So emphasizing the importance of bringing issues to management before they lead to discipline is going to lead to a much more productive workplace and hopefully cut down on the situations where where an employee has let the situation go to such an extent, or a manager has let a situation get to such a place that discipline is the only thing that can get everybody's attention. So we talked about clarity. Now communication, right? Letting employees know when they're not meeting expectations or when their conduct is not consistent with your policies is more important than just a once a year performance review. Letting employees know along the way, having those informal check-ins so that you can act promptly and make sure that the individual understands, I am not meeting expectations and this is how I have to act to fix the issue. Again, stemming those problems right as they're happening is going to make for a much more productive workplace and hopefully avoid a situation where you need to impose discipline. So it's communicating with employees and communicating on a regular basis with your supervisors and managers. They are the ones that are having those boots on the ground communications with employees. So they need to be reminded, again, this is not just something that you let fester and then bring to HR to say, I need to terminate that person. There needs to be reminders to supervisors and managers of the importance of ongoing communications with employees, the fact that HR is available for consultation at any time to make sure that they're handling things correctly, or if they run into a situation they don't know how to deal with. Because as we all know, HR will tell them, document, document, document. And so that reminder is critical. So in terms of documentation, the communication piece here is there's two times really when the communication, where the documentation should be done. As situations evolve, it is important for supervisors in collaboration with HR to be keeping a contemporaneous record of specific examples of performance issues or misconduct. Make those records and documents promptly. Make sure that they are being addressed promptly. So as things happen, especially, the big things, we're not nitpicking here, we're not micromanaging, but we do want to make sure that the specific examples of the incidents that could lead to discipline are documented at the time. But obviously, there are times where an employer or supervisor might not recognize a pattern. The first time somebody calls in late, the second time they show up late, maybe the third time they leave early, but if they're separate in time enough, it might not indicate a pattern. And so maybe it wasn't fully documented. But at some point, if a pattern emerges and if the employer is planning to take or needs to take discipline to correct that pattern, there's an opportunity to reach back and say, we're having this meeting with you today. Here are some incidents that we've recognized in the past. Now we recognize this pattern, and here's what we need to do moving forward. So there is an opportunity to go back and maybe capture some earlier incidents. If you miss the boat the first time, there's often a time to correct that. So another part of setting up for success is consistency. Applying the rules consistently and fairly, and making sure that managers are trained and reminded on a regular basis about consistent application. And that's where HR and collaboration with HR is so important, because a supervisor or manager caught up in the daily business might not recognize the differences in various situations, or because they're just dealing with the group of employees who report to them, might not understand that another supervisor does things differently. And the employer is the one that's going to have to show that it acted consistently with employee A and employee B. So involving HR to make sure that the employer itself, even though there are different supervisors involved, is acting in a consistent way is important. That all of those things, easier said than done, probably. are all important to make sure that you are putting yourself in the best position possible to move forward with some form of discipline. So next step is the decision-making process. So several situations could lead to possible discipline. If an issue of performance or attendance arises, there's a couple of different ways to deal with that. It could be a formal or informal performance review, sitting down with someone and just giving them verbal coaching. It could be a more detailed performance review. And part of that can be a conversation about what's going on. This is what we've noticed. This is what we've seen. It seems this was something you were doing well before. Now we're seeing that you're struggling. Is anything going on that we should know about? And giving the employee an opportunity to disclose that there might be some issue. It could be a disability, it could be a family issue. Something is going on where they just need a little bit of an opportunity to catch their breath and maybe refocus now that they've had that one-on-one with a supervisor or perhaps involving HR. And if you're talking about disability and accommodation, absolutely HR should be involved. So look at the nature of the issue. If the issue is performance, there's a couple of ways to deal with that. If the issue is an ongoing performance issue or an attitude issue, an insubordination issue, consider a performance improvement plan. And those aren't, the magic bullet by any means, but often somebody who has a performance issue and is dealt with, not in a very formal way, might say, well, I didn't really think this was much of a problem. They mentioned it to me, but I didn't realize my job was at stake. A performance improvement plan is an opportunity for everybody to look at the situation and figure out what is going on and what to do to fix it, but also what the consequences might be if they are not fixed. So a performance improvement plan, going back to the clarity and communication, it should be very clear what the time frame is for improvement and what improvement looks like. So it can't just be nicer to your colleagues, right? It really should be a little, digging into what are the specific issues that we're seeing, what are the clear objectives, and how can we measure that? So that takes some doing, that takes some thinking. It takes some clear discussion with the employee, and from a supervisor's perspective, what is going wrong with this individual, and how can I measure when they have gotten to a point that they are meeting expectations. The performance improvement plan should also talk about periodic check-ins. How frequent are they going to be? Who else is going to be there? What homework does the individual have? And what are the expectations of participating in that meeting, and what needs to be shown at that meeting? So I've had employers say, we're going to meet every other week. And at the beginning of the meeting, you're going to show me your list from last time about things we said you were going to do, and you're going to show me what you have done. And at the end of the meeting, we're going to create a new list, maybe some carryovers, but some new things about what needs to be done. And, some of those, again, measurable goals, that's the ideal. Some of those things, I need to make X number of phone calls, or I need to complete X number of reviews of these files, those types of things. Obviously, it's a little bit harder if it's an attitude issue. You know, zero conflicts with coworkers is obviously the ideal, but it's the check-ins, it's making sure that those check-ins actually happen, and it's the clarity of the objectives and the expectations that will make the performance improvement plan successful, if in fact it's going to succeed. But make sure that even in a performance improvement plan situation, that the employee understands that they are still at will. So just because the time frame for improvement might say 30 days, 90 days, that doesn't mean they have a fixed 30 days of employment where nothing can happen to their job. It still should be emphasized that they are at will. The other thing about performance improvement plans, and this is short-circuiting to a termination issue, it is often a time, if you have a very problematic situation, when you present somebody with a performance improvement plan, to mention to them, this is not going to be easy, right? These are the expectations, and there's going to be more oversight, and it's going to, involve some close observation of what you're doing and how you're doing it and how you can succeed. Some folks don't want to go through that process. And if the alternative of a separation package would be of interest to you, we can look at for that. So I find sometimes employers are like, why do we have to go through that process where we know the individual doesn't want to be here? We don't want them there. This is potentially an option to say, this is what we're going to do. This is what we're prepared to do, but maybe there's an option, an alternative. So back to the decision-making process. If the issue is alleged misconduct, something egregious, stealing, threatening, violence, something along those lines, ask yourself whether an investigation is necessary, or is there a clear breach, an admitted breach of a workplace rule, right? An investigation is likely necessary and almost always necessary if there's an issue of sexual harassment, other form of workplace harassment, discrimination, retaliation. But if somebody brings a weapon into work and threatens somebody, there's not much of an investigation that needs to happen if it is observed and admitted, and that's a breach of a workplace rule. So evaluate whether an investigation is necessary. And if so, follow your standard investigation process, which again, it's great to outline that in your handbook. Confirming the facts. The facts can be confirmed with the person who's complaining about it, any witnesses, through documents, and then also with the person who's the alleged aggressor or accused. Confirming those facts, confirming the documents, confirming the messages. Give the employee who's accused an opportunity to explain or respond, explain their behavior or respond to the allegations. And then document the investigation process and the findings and the actions, so that if your decision is ultimately challenged, you have contemporaneous notes of what was done, how thorough, prompt, and impartial your investigation was. And as noted, that's kept in a separate investigation file. Another factor in the decision-making process is whether you have a progressive discipline policy in your handbook. So those policies are often, if something happens, we'll first do verbal coaching or counseling, then a written warning, then suspension, maybe with pay, maybe suspension, then without pay prior to a termination. Those progressive discipline policies, if they're in place, should give the discretion to the employer to skip or repeat steps. So in the instance of somebody bringing a weapon into work, you don't have to give verbal counseling, right? Depending on the severity or frequency of the conduct, skipping right to a suspension or a termination might be the next appropriate step. So making sure that there is discretion, in that policy is important. And then for each particular situation, you'll need to decide whether you should, in fact, skip or repeat a step or move to the next step. So if somebody is verbally counseled for being rude to a coworker and then misses a deadline, that might just be repeating verbal counseling. They're not the same situation. So it's again, a fact-based case-by-case determination. If the next step is termination, you're going to want to make sure that there's sufficient documentation to justify the decision. And this is where many of the calls that we get, HR will call us and they will apologize right up front. You're not going to like the amount of documentation that we have, right? We've talked to supervisors. They say they're documenting enough, but when we went back and looked, it's really sketchy, or there's some holes in this. So this is often where there might be some initial pushback by HR, or if HR calls me, there might be some real digging to find out what does the documentation look like, how comprehensive is it? Is it now, are we relying on documentation that happened before they were coached? And now this is the first time since they were coached, but we're relying on something that was earlier. So you want to make very clear that you have the documentation in place, that it covers the incidents or the misconduct that you want it to, and that you are paying attention to what discipline or progressive discipline has been imposed along the way. So we have a really good idea of whether, in fact, termination makes sense. So looking at the sufficiency of the documentation and how recent it is and who did it is always some of the questions that I ask right up front. And knowing whether HR has been involved is critical, right? If HR has not been involved and a supervisor comes forward and says, I wrote him up 4 times and it's time to terminate, and this is the first time HR is looking at this, HR is going to want to put on the brakes and just make sure that there's a review of the situation. Is this consistent? Has this supervisor acted consistently in writing up other employees? What is different about this situation? And just taking a step back and taking a breath to make sure that the documentation and the consistency sort of meet the smell test. So I have 2 slides just listing a bunch of questions that could be appropriate to ask. And this is the double checking phase. And I can't say enough about double checking, right? As I've said, HR often calls us and says, this is what we want to do. Can you just make sure that we're doing the right thing? And I would encourage HR to have done these types of this type of analysis much earlier than calling the lawyer. Now, I understand there's a lot of times where HR is kind of backed into a corner by a supervisor who says, this has to be done right now. We have to let this person go right away. And it is a really good thing to be able to say, we have to check with legal, right? I get that. And we are happy to serve as that, I guess, excuse to slow things down, right? Because we want to make sure that an employer is taking the careful steps that they need to make sure that they're going to avoid legal trouble if at all possible. But once a decision has been reached, at least initially, it's really important to go back and double check your work, right? We want to make sure, first of all, does this employee have some sort of contract? Most employees will just have an offer letter, which says this is not a contract. And the offer letter will confirm this is at-will employment, and you can be let go for any time, at any time, for any reason, as long as that reason is not unlawful, right? That's what most employees will have. But pay attention if an employee might have some sort of written agreement, an employment agreement that gives them the right to advance notice before any termination happens. And some employers will have, employees will have an employment agreement that says you cannot be terminated except for cause. So we see this a lot with medical practices and executives, but other folks also who may be key to the organization or who may just have benefited from a very generous employment agreement, there may be some additional steps required if there's a for cause only termination. And often the way these are set up is that without cause, terminations can happen, but they need to give a sufficient amount of notice, whereas a for cause termination will need to go through certain steps. And for cause is often should be defined in the agreement as things like fraud, dishonesty, conviction of a crime, harassment, material breach of your job duties, and things like that. Things that kind of rise to the level of something that's egregious or intentional. And so you want to make sure that you understand whether the employee has a contract so that you know, do we need to go through any more hoops to clarify this or to characterize this as a cause termination where we might be able to act immediately as opposed to a without cause termination where we might need to pay them for some additional time. I do see some questions, so I want to see any advice for when an employee is passive aggressive towards HR. I would say in that type of a situation, that is something that can be dealt with on a performance level, right? You have an expectation of your employees to deal with HR appropriately and to be collaborative as well. And so that again could be something that is dealt with in some sort of counseling discipline or even a written warning if they are passive aggressive, if they're not cooperating. But in most cases, you're going to want to, I guess, call that out, right? I've asked you for assistance. You've said there's nothing wrong, or you're, doing something else that appears to be disrespectful to HR. And let's talk about what's actually going on here. So I'm a big proponent of having a respectful conversation if you feel that HR is not being respected and is not being listened to. I'll deal with another question. I can deal with that now as well. The other question is, how long is appropriate to wait to take action if someone is coming off FMLA or any other type of leave? So you'll see a couple of bullets down on the slide that we're looking at. Is the employee on light due or returned from leave? It's absolutely critical to make sure that you are paying attention to the sensitive period of time that happens after an employee returns from leave. There's not any magic bullet. I will say that if you're in Massachusetts, those of you who may have employees in Massachusetts, and other state laws may have this as well, but in Massachusetts, if someone comes back from a paid family medical leave under state law, it is presumed that if anything negative happens to their employment within 6 months after they come back from the leave, that is presumed to be retaliatory, unless the employer can show by clear and convincing evidence that they would have taken that action anyway. So basically what that means is in the 6 months after somebody asks for or takes or returns from a paid family medical leave, if there's anything that you're going to do to their job in that first 6 months, you want to make sure that you have been really clear about your expectations and your documentation to show how they have not met those expectations, and that you would have treated another employee or that employee exactly the same, even if the leave hadn't happened. So that's Massachusetts, and again, other states. I know we have many employers on the line who are multi-state. So you're going to want to be very conscientious of what your leave laws are and whether there's this presumed period of retaliation. But even if it's not a stated period of time, understand that in all situations, if anything looks retaliatory against that employee because they just took a leave, that employee is going to have very willing plaintiff attorney ears listening to them. If they say, I just came back from leave and I was late one day and I got fired, but Sally is late all the time and she's still there, right? So you're going to want to make sure, again, setting yourself up for success, that you are setting up clear expectations and that you're being communicative, you're consistent, and you're collaborating with HR. But there's no set time frame, except that you want to be able to show you would have done it anyway. And by the way, some employers are just about to issue discipline when somebody goes out on leave. I'm sure many of you are nodding to that happens to you as well. And in those situations, it is often appropriate to say, we're going to postpone any discipline discussion, let you take your leave, but when you come back, we're going to have a conversation about our expectations. And sometimes the reason for the leave can be solved. The reason the disciplinary issue can be solved because the employee takes the leave, right? If they were having attendance issues and they went out and they got treatment and now they're able to come back and not have attendance issues, it may be resolved. So be aware when they come back from leave, there may be discipline issues that happened beforehand, that some of those you can carry over. And sometimes it's just a good conversation about what the expectations are going forward. So jumping back to our double checking list, you want to make sure you know whether they have a contract and that you have followed that contract. You want to understand if it's cause or without cause. Does that impact severance? And if it impacts severance, understand that if you jump to a for-cause termination, you're going to have an employee who has an incentive to challenge that. So you want to be very, very solid on your cause terminations. Is the employee in a protected class? Or have they been on light duty or just returned from leave, which we just talked about? Have they complained about workplace safety issues? In other words, are they a whistleblower? Have they complained about harassment or participated in a recent investigation? And in other words, all of those really suggest the hesitancy that you should have in disciplining or terminating because of the fact that it may look retaliatory for someone having engaged in protected conduct. That's not to say that you cannot move forward. It just means that you need to be solid in your documentation and your consistent approach to how you discipline employees in the workplace. The same goes for if the employee has complained about wages or other terms of conditions of employment. So under the National Labor Relations Act, employees do have that right to be vocal about their wages and their dissatisfaction with wages or other terms of employment. And terminating somebody because of that is could be retaliatory, would be a precursor to legal action. So you want to make sure, again, that you've been solid in your documentation and consistency. Other questions to double check, hold on, to double check before you pull the final trigger. Has this employee been disciplined before? So that leads to do we have a progressive discipline policy? Where are we in that process? Do we skip a step? Is the discipline for the same thing? Or do we have a larger problem here? Have we documented the key incidents? Have we done a sufficient investigation? Do we make sure that the policies we rely on are clear? I mean, it is not uncommon for me to get a call from an employer saying, we need to terminate this person because they did X, Y, or Z. And if I ask, do we have a specific policy on that, or what does your policy say? Sometimes it's not in the policy. There's nothing in a handbook. It's just an expectation that they say, well, that's common sense. And often it is common sense, but if you can point to a policy in a handbook, in a termination letter, that is going to be it's going to take the wind out of the sails of an employee who was terminated and their employment attorney. Have we followed the steps required by our handbook? Again, this is the progressive discipline. Some employers actually include a grievance process. The investigation process is often listed in the handbook. So look and see what, if you would call it required by our handbook, right? Remembering a handbook should not be a contract. But if you have set out expectations for the employee, are there policies or processes in your handbook that the employee would expect you to follow? Um, and have you followed those? The big one here, do we need to pause for any reason? Everybody may be on the brink of terminating, of moving forward with a termination decision, but is there any reason to pause? Maybe that employee is the only person that knows how to do a certain thing, or is the key contact and has all the good relationships with a particular customer. Is there an opportunity to transfer knowledge here? What do we need to do to shore up the relationship with that customer, for example, before we part ways with this employee? And then the big one is, have we left ourselves enough time to get the final paycheck? This is more of an issue for Massachusetts and other states because the paycheck has to be given at the same time or on the same day as the termination. But still, 72 hours in New Hampshire, you have 72 hours to issue the final paycheck for termination purposes. And what if you do this on a Friday morning and your accounts payable person is on vacation that day? You have not left yourself enough time to make that, to meet that final paycheck obligation. Sometimes you'll get the call from a very frustrated supervisor that just says, "Look, this is the last straw. I can't take this. This person is done. I'm done. I'm never working with them again. We've got to get rid of them right now." And if HR can be the voice of reason to say that may be, but let's get there a little bit more slowly when tempers have cooled, right? Sometimes just taking that breath for a day or a weekend will show that perhaps there's a reason to pause and maybe take another disciplinary step instead of termination. Do you have complete documentation? I have been involved recently in a harassment investigation that I was consulted on, and every time the employer thought they were done with this investigation, one or the other of the parties would present them with another text message or another email or another piece of information. And I think my client summarized it very well, saying that everybody on the HR team has investigation fatigue. I really empathized with that. You know, they thought they knew where this was going. They thought they had everything, and now something else comes up. But every time that new text or new email really made a difference in helping them understand the full picture. And so the result was different than they thought it would be, even, you know, in the first couple of days after the investigation. So understand that investigation fatigue and discipline fatigue are real things, right? You just want this done. Management wants this done, but sometimes taking that pause will really help you get to the truth. What discipline has happened in similar situations? That's key about the being consistent, because you don't want to look as if you have treated somebody in a protected class or who has engaged in protected conduct differently from someone else. So look at, you know, are you comparing apples to apples in how you have disciplined others? If we're planning to be more strict here, why? What is the explanation? Because if this is ever challenged, that will be the key to any litigation. Looking at some questions. Is there a time frame associated with someone who brings a harassment claim? which was investigated and determined to be unfounded. Again, I would say understand that when you have a situation that is considered protected conduct, so complaining about wages, helping somebody with an investigation, bringing a harassment claim, those are examples of protected conduct. And or saying I have a disability, and just saying that and expecting the employer to back off. In all of those situations, the employer is uh, really supposed to take very careful action before they do anything that could look retaliatory. And in many cases, I think employers are afraid of doing that, with good reason, right? Because they don't want to get drawn into discrimination or retaliation claim. But in all cases, your workplace expectations still matter. So if you are in a situation where somebody has come back from a leave or they've brought a complaint and it was unfounded, and you've closed that and let them know this is unfounded, or you're back from leave, now we're moving forward with your job expectations. If there is some independent, well-documented, clear reason that they are not meeting your expectations or that they are engaging in misconduct, you can still take action. Again, all of this involves HR knowing what's going on and probably running in by employment counsel to get yet another view of the situation. But if somebody brings a harassment claim and it was determined to be unfounded, um, and they have a separate reason that they're not performing well or that they're engaging in misconduct, then that is something that the employer can figure out. How do we discipline this? Like, it can be disciplined. What is the disciplinary step that we're going to take? If a harassment claim is brought and it's unfounded, and it's not just unfounded, but it is found to be false, that is certainly something that the employer can take a disciplinary step. Where that discipline falls in the continuum of progressive discipline is something that has to be decided based on all the facts. Another question, what if you can show documentation or performance issues were happening prior to the leave? That is, again, one of those situations that if you're documenting it and you've held on to that, understanding the person's going to take a leave and you probably don't want to hit them with that on the way out the door. It might aggravate whatever their reason for leave is, make the leave not be as successful, or it's not really purposeful because they're going to be on a leave and they can't fix their conduct right away. So if you have performance issues and you've documented them, then when the employee comes back, often in the days before they come back, they're confirming, I've been cleared to return to work. If they have a doctor's note, here are my limitations, here are the accommodations that I might need. You can go through all of that and then say, and as well, when you come back, we're going to be talking about some performance issues that existed before you went out. And we want to make sure that we're all on the same page about what happens going forward. Okay. So just to emphasize the importance of double checking, the elephant in the room is a lot of these things can lead to legal liability, right? So you want to make sure that you're evaluating the legal risk of a termination decision. Do you have a solid basis? Have you treated people consistently? Is there a basis for the employee to say it was discriminatory or retaliatory? And there's been a rise in reverse discrimination claims as well, right? So people who are the harasser saying I was unfairly terminated, or people who say you treated other people in a based on their race differently than you treated me, a white male under 40. So there has been a rise in those types of cases as well. which basically means it's all the more important to make sure that your policies are clear, your documentation is as close in time to the infraction as possible, and that you've involved HR to make sure that everything is being done consistently as as the person would have been treated, regardless of race or age or other protected characteristic. And then checking with counsel is, uh, obviously something that I would advocate for, only to make sure that you're not missing something. You might not recognize, for example, that there's protection under the mass paid family medical leave. You might not be aware of some aspect of this that you should be paying attention to. So double checking with counsel, again, is something that a lot of employers do. And again, if we can serve as the reason that you need to just press pause to make sure that you're doing it right, we're happy to serve that role. So planning the termination meeting, assuming that you've reached that point where the employee and the company need to, or the organization need to part ways. The implementation of this is almost as important sometimes as the actual decision. You want to make sure that it's handled in the most humane way possible. So first, decide who's going to attend the meeting, who's going to lead it, and who's going to be a witness or, taking notes, the scribe. And it can certainly be a tag team, but if there is somebody who is really serving as taking down all the notes that might be needed, that's going to free up the person who's leading the meeting to really focus and pay attention, watch body language, and pay attention to what they're being met with. Is the person upset? Is the person, humbled by this? What and have to be able to just, I think, to have an actual person-to-person conversation is going to make that person feel heard to some extent. Obviously, if you're terminating somebody for an egregious violation, it's going to be a very, very quick meeting, and there's not a lot to take notes about. But decide who's going to be at the meeting. Can also be who should not be at the meeting. Is there somebody that has a really significant conflict with that person? Maybe with the employee, let's maybe keep that decision maker out of the loop, out of the meeting, so that the meeting can be as respectful as possible. Make sure that you have your paperwork together in advance of the meeting. And that can be a termination letter or a separation agreement if you're going to be offering any sort of severance. Make sure that you have the final paycheck if it's required at that time, or can it be direct deposited or delivered separately, and unemployment information. Even if you're planning on challenging unemployment, in the rare circumstance that happens, it's important to give that information about how to file. Prior to the meeting, informing the affected supervisors and managers in a confidential manner, making sure that they're aware they're about to lose an employee. And often they will already have been aware of that and perhaps even involved in the decision. Figure out what information you need to get from the individual, from the employee. Do they have passwords? Do they have credit cards, keys, badges, anything like that? Do they know some information that you might not know, like the location of certain files, et cetera, or the status? Obviously, in a performance discipline meeting, that's going to be, I think the employee should not be surprised by, when you reach the point of termination, the employee should not be surprised. And so hopefully you will have already gotten from them information about pending projects and locations of files. But to the extent that you're acting more quickly for other types of disciplinary reasons, there may be some key information that you can try to get. And otherwise, you might be reinventing the wheel to some extent if you have to let this person go quickly. Prepare your talking points. is very important so that you're not winging it and not saying something that is inconsistent with the actual reason. You do not, in a termination meeting, want to give any suggestion. You want to be very clear about what the reason was so that later somebody can't say, well, my supervisor also said it had to do with this, which is the reason, because you didn't give me the same reason. It must be a pretext. So you want to have your talking points prepared so that they line up very well with whatever you said in a termination letter or a separation agreement, and so that all the messaging is consistent and that you stick to the script and don't get drawn into a longer discussion, which we'll get to in a minute. You'll want to discreetly inform people who need to know in advance of the meeting. So someone in finance who's issuing the final check or calculating what is owed may need to know, and it will need to know in advance, most likely. And IT or facilities who's ever cutting off electronic access or physical access, cutting off badges, et cetera. Those folks will need to know so that most likely during the meeting, the access can be removed. Deciding on a location. And that can be also deciding what type of a format it is. Ideally in person, but virtual, especially if you have out-of-state employees, might be really the only option. But both of those are far better than a phone call and definitely better than just a letter or an email. Although sometimes if an employee is not responding, say they're, you know, just have stormed out of the building and are not responding to you, a letter or email notifying them that they've been terminated and that they're not permitted to come back is definitely an option. Make sure that there's no interruptions and balance between employee privacy and safety of attendees. So maybe not doing the meeting in a fishbowl where everybody walking by can see, but also not necessarily, you know, at 7 o'clock at night with just the employee and two other individuals in a desolate workspace. So you want to think about all that carefully. Inviting the employee, you know, you don't have to say that this is anything formal. You don't even have to say who's going to be there. But you know, inviting the employee, hey, can we talk about something is an appropriate way to go. Again, in most cases, it would be ideal that the employee not be surprised that their performance, for example, is headed in the wrong direction. So they won't necessarily be surprised to get this invitation from HR, for example. During the meeting, be kind but firm. In most cases, this is going to be the way to go. Obviously, if there is some really egregious action, being firm is the most important and being direct. But still, in every situation, being as constructive as possible rather than demeaning is going to leave the employee feeling a little bit better about the meeting and potentially less litigious. Be succinct, stick to the facts. Don't characterize what they've done, but really, unless that, you know, you can characterize certainly that there's been a violation of your rules, but be very succinct. Give some leeway for the employee to share their perspective, but you definitely do not want to get into a debate about the decision. And in some situations, again, for more performance related, or depending, you know, this might be a very, very senior employee, giving them an opportunity to resign as opposed to calling it externally a termination is going to preserve some dignity and might be the way to go. There should be verbal instructions given to the employee at the time of the meeting that they have to return their property, whether they're going to be allowed some time to pick up their stuff or whether they should leave right away. But after that, there won't be any access to premises or to your computer systems. Making reference to a termination letter or a separation agreement. And if there is a separation agreement, giving just a quick overview of the deadlines and who to contact with questions. I mean, that's really critical. You want to narrow the universe of people that this employee communicates with after the fact So give them either their supervisor or HR or both, but really make clear we are the people who know, who have the answers to the questions that you will ask. So it is really important to communicate with us directly. And if you want to say, they should to discourage them from contacting any others, you can certainly do that, but understand you really can't control who your current employees talk to. Uh, Although the remaining employees can certainly be told, you don't have an obligation to answer those questions from the terminated employee. Documenting the termination. Before termination meeting, several of my employer clients do prepare a full memo laying out the whole situation. And that really helps crystallize what the issues are and what has been done and what, policies have been violated and what efforts have been taken. And in some respects, I think that that's helpful. I don't think many employers have that time, frankly, to do a full memo like that. They will pull together all the pieces, but they won't do sort of a summary memo. But it, again, is a good way to at least capture the progress and the process. But in most cases, a termination letter to the employee notifying them of the date of the termination, the date that benefits end, and how to apply for unemployment, and the reason for the termination, it helps sort of dispel the thought, I was terminated because I participated in a harassment investigation. I was terminated because of my race. If you can spell out, you were terminated because you were absent 3 days in a row and no call, no show. You were terminated because you missed 7 deadlines and we gave you an effort and then you missed another one. We gave you another opportunity and you missed another one. So really being succinct about the reason for the termination in a letter to the employee. It will be the first thing that they show a plaintiff side employment lawyer. This is the letter they gave me, and it helps frame that conversation, even though you're not going to be there. If you do prepare a separation agreement offering severance, you can choose to give that to the employee at the time, but sometimes they get really bogged down with trying to look at it and try to understand it. It may be appropriate just to say, we're going to give you a separation agreement and we're going to give you time to look at it, but here are the high points. So at the termination, if you provide those documents or say that they're coming, that will be another point to cover during that meeting. And then after the meeting, prepare a note for the file that the meeting was held and any key points. So that's sort of what that witness can do after the fact. And that's a document that doesn't need to be all that descriptive, other than, the employee stormed out without hearing the rest of what we had to say, or the employee was very apologetic but understood. That might be helpful to have to go into their personnel file. So I mentioned a termination letter and a couple of things that could be included. Final pay, making sure that if the person is salaried in New Hampshire, that you pay the full pay period, unless you have a for-cause termination. But again, that's fairly rare. So most cases, you're going to want to pay the full pay period. And then again, because I know we have Massachusetts employers on the line as well, making sure that you have the final paycheck either in hand or shortly afterwards, but that same day. Making sure that you let them know the timing of the end of benefits, and that can mean, your benefits end either today, March 12th, or the end of this month, March 31st. And after that, separately, you will get information about COBRA and how to convert any other employee benefits. You'll have to decide whether you pay out PTO. What does your policy say? If you don't have a policy, what is your practice? Again, in Massachusetts, you don't have an option, but in New Hampshire, you do, if your policy is clear. What is the impact on options, equity, bonus, commissions, other sorts of things? That is helpful. Just again, in even if an employee may be expecting a termination, it's still probably going to be a shock and they'll have a lot of questions. And to the extent you can outline the key points in a letter so that they can refer back to that because they probably won't remember everything that happened during that meeting. It's a good reference point for them to be able to refer back to. Again, unemployment information. And then if you have an employee assistance program, that might be something that you also offer to former employees or terminated employees for a short period of time, especially if you think it might be helpful to have them come to terms with what has happened. Biggest concern from employers sometimes is we got to get back our laptop. We have to get back our files. We have to get back our equipment. And in a lot of cases, that won't be a problem. Understand you cannot withhold final pay while you get that equipment back. And some employers do have, an incentive to even file a small claims action against an employee who won't give that equipment back. Although a lot of employers decide it might not be worth the effort if they cannot get a particular laptop or monitor back. But do what you can to get your equipment back and remind the employee during that meeting and in their termination letter. And then reminding them of post-employment obligations. If anybody has a confidentiality or non-disclosure agreement, or if they have a non-solicitation or other restrictive covenant, reminding them of that in a termination letter is the appropriate way to get that back in front of them, maybe even giving them another copy. But I doing it this way without having them sign anything, it has the best chance of leaving that restrictive covenant intact rather than giving them a separation agreement that mentions it and has them sign, ask them to sign the separation agreement. If they refuse to sign the separation agreement, they may say, my post-employment restriction didn't apply anymore because I didn't sign that separation agreement. So reminding them separately that if they have such an agreement, that it remains in place. So I'm going to, in the interest of time, a separation agreement can include many different types of terms, whether there's continued pay or benefits. If you're going to pay into COBRA or cover their COBRA for a while, you want to make sure that you understand, do they have to elect COBRA and then you reimburse it? How's that going to work? You want to make sure that you have a very complete release of claims if you're paying anybody's severance. We often will help employers make sure that their release in the agreement complies with the state law where the employee works. You want to make sure if there's an age discrimination possibility that you follow the age discrimination release requirements that I'll cover in the next slide. You want to make sure that a releases all claims except those that cannot be released. For example, they still can participate in an agency proceeding like the Human Rights Commission or the EEOC, but that they are waiving any monetary recovery if they sign it. Then there should be some acknowledgments. If you're having them sign something and you are giving them money, you want to make sure that there's nothing else out there that you don't know about. So I've included a couple of the acknowledgments that might be included, and there are certainly more. I mentioned age discrimination. I just want to spend a couple of moments on this. If somebody is age 40 or over, then under federal law, if you ask them to sign a release, you have to go through a few extra hoops to make sure that you are obtaining an appropriate age release, a release of age claims. So the release should specifically mention age discrimination and ADEA, Age Discrimination in Employment Act, and OWBPA is the Older Workers Benefit Protection Act. So that law should be mentioned. And it should be clear that any age claims arising after the person signs the agreement are not waived. You're only releasing claims up till the date that the employee signs the agreement. The release should be clear and understandable. It should give consideration, in other words, money, in this case, severance pay, beyond what the employee is entitled to receive. And it should tell the employee that they have the right to consult an attorney at their own cost before they sign. But the a real differentiator in a release for somebody who's over 40 or over versus somebody who's under 40 is the time that you need to give them to decide whether to sign the document. And so in a separation agreement, we're asking for an age release. You have to give the individual 21 days to the individual who's 40 or over, 21 days to consider whether to sign, and 7 days to decide after they sign whether they would like to revoke or rescind their signature. In situations where you're terminating a number of employees in a reduction in force, they get additional time beyond the 21 days. But for a disciplinary discharge that we're talking about today, it would be a 21-day consideration period, which they can sign immediately the next day or day 21. But then they can revoke after 7 days. And you want to make sure they know how to do that. You want to make sure that you're not paying separation pay until that revocation period is all done and they have not revoked. And then if there's a period of time where the employee, say you tell somebody today that their last day is Friday, but you give them the release today and they sign it today and they stay employed for several extra days, you will want to have them sign a reaffirmation of the release and a confirmation that the release they signed on Wednesday only covered claims up till Wednesday. They stayed through Friday. Something may have happened in the interim. Have them sign something additional. So we work with employers to make sure all that timing is consistent and that you've got all the bells and whistles in place to make sure that you have an effective age release. Additional terms might be if you're imposing new post-employment obligations, a new confidentiality or new non-disparagement provision that the employee had not signed before. Mutual non-disparagement, it's not going to be a mirror image. And what I mean by that is the employee might say, you can't disparage me or my reputation, and I won't disparage the employer or its reputation. That can't be a mirror image. And what I mean by that is the employer cannot control what non-supervisory employees say. So if you enter as an employer an agreement that says the company will not disparage, the company and its employees and agents won't disparage you, you cannot control what the lower level employees say. So you want to make sure you carve that out to be just the upper, the supervisors and HR and management. It won't disparage. You may want to include a no rehire clause. You want to include what happens if there's a breach. So they have to pay back separation agreement, a separation pay. You want to make sure that this is the agreement that will really control the employee and company's relationship going forward. So you want to make sure that you've considered what other agreements there might be that you want to continue. And you want to make very clear what the date for signing is and what happens if the employee doesn't sign. So you're still going to be terminated, but you won't get these benefits. Messaging is our final topic. Be aware of the issue of defamation. And there have been more defamation cases over the past 5 or 10 years where somebody says, I was fired, and then they went and told the whole company about it. And it basically suggested that I had done something criminal or really egregious. So be careful what you say to other employees. Obviously, they're going to know that the person is no longer employed. But if you need to say anything more than that, keep it to the group of people who need to know and keep it factual. Externally, it may well be the only thing you need is an email message that says so-and-so is no longer with the organization. Contact a different employee to answer your question. So it may well be there's not a lot of information that needs to be disclosed, but saying anything beyond the employee is no longer employed you should make you pause and figure out why you're saying it and what you're saying. So basically, just to close, the life cycle of the disciplinary termination is to be clear, to communicate with the employee, with managers, with HR, to be consistent, to collaborate, to make sure that you've got all your stuff together at the time you need and that you are working as a team to exit this employee. And I'll just add one more C is compassion, right? Because understand any discipline issue can be a real reflection. It can feel like a reflection of the individual's worth, and understand that they will not react kindly to things that are demeaning or feel things that they feel that are unkind, and that may be the reason that sort of taste in their mouth when they're leaving is what may be the reason that they move forward to get legal counsel. So those are the topics I wanted to cover today. I'll look at some of the questions and take a couple of them, but I also want to make sure that you all have this slide, which I know is very important. So I thank you for your attention today. For those of you who need to jump off and get back to work, but I will look at a couple of these questions and take on a few. But again, thank you for your attention. Okay, so if an employee in Massachusetts comes back from a paid leave and is laid off less than 6 months after their leave, is that still considered retaliatory? So again, under the Mass Paid Family Medical Leave, if something negative happens within 6 months, it's presumed retaliatory unless it would have happened anyway. So you will want to make sure that you have very clear documentation that this employee would have been laid off with maybe with others or because of a elimination of a job, and you can justify that. So you always will have the chance to show by clear and convincing evidence that you would have taken this action. What if someone was on leave and now on the list for a non-renew for a teacher? Can we non-renew a teacher, which we do not need a reason in that case, if they have just come back from FMLA within the past 6 months? So I do want to be clear, FMLA is federal. The federal law does not have this 6-month window. There is an anti-retaliation provision, though. The anti-retaliation provision says you cannot retaliate against somebody for having taken FMLA leave, but the FMLA regulations also say that if somebody was on leave, they should be returned to their position unless, because of reorganization and other legitimate business needs of the employer, the job there's no job for them to return to. So again, it's a matter of really being diligent in figuring out, would this person have been on the non-renew list regardless of whether they took the leave? And if they would have been on that list, why would they have been on that list? What can you clarify why? So you just want to be able to substantiate that you made this decision regardless of the FMLA leave. But the FMLA regulations do allow employers to continue to manage their own operations, which means they may change the number of employees they have in certain roles. Okay. So what if while an employee was on leave, you discover several deficiency issues that need to be addressed? Is it considered retaliatory? So if you discover that you didn't have an opportunity to address it with them while they were on leave, then when they come back from leave, you can have a conversation. This is what we discovered. We want to level set here. We want to have a discussion about what the expectations are. If it's so egregious that you need to take discipline, you're just going to want to have it documented and want to show that you would do this consistently in every case. But you can certainly, when somebody comes back from leave, have a conversation about what your expectations are and how they didn't seem to be meeting those expectations and how they can meet them going forward. What if you make a check available in office if the employee works remote? Does that meet the spirit of the law? So, I would say no. New Hampshire, you have to pay within 72 hours. There are ways to get a check to the individual, FedEx, overnight mail, 72 hours. In Massachusetts, the way to deal with this is potentially to suspend the individual, let them know that they're suspended, that their access has been cut off. They're not going to be providing any more services to the organization, but the termination date will be several days later, which will give you a chance to do a direct deposit or an overnight mail, FedEx or something like that. So do you recommend not including the reason for a termination? And I would say if providing a reason will answer the employee's question, like, was I terminated because of my race? Was I terminated because of my age? If you can answer that question for them, it seems to be a step in the right direction. So did you say that in New Hampshire you have to pay out the full pay period? That is for salaried employees, not for hourly. For hourly employees, it's just the last full day of their employment. But actually, if you have them come in to be terminated, you're going to have to address pay the 2 hour reporting rule. But for salaried employees in New Hampshire, you have to pay the full pay period. Do you suggest always having one extra person in a termination meeting? I think that that's a smart move because you will have, uh, just a witness to what happened. And that way you can really choose. You were able to have a little bit of a buffer, right? And so maybe there is somebody who that person feels gets them, and that they respect. And if that person can be in the meeting, and maybe HR is somebody that they've had problems with, or maybe they don't feel that HR has ever listened to them. You want to try to put the team together in a way that can at least give the best shot at success. And I think having one extra person is a good way to do that. Okay, so this is the last question on here. Different than involuntary termination, but in a voluntary termination, New Hampshire law states if they provide notice, you have to give them their final check within 72 hours of the last day. So that's a resignation. I've had a lot of employees saying they don't want a manual check within 72 hours and they want to get direct deposit on the next pay date. Can I have them sign something that they are waiving their 72 hours? I haven't seen that specifically. I would say that having something in writing is better than nothing, but I don't understand uh, why they wouldn't want a manual check. And I would see if you can maybe just do an additional direct deposit, rather than um, violate, the statement, the stated purpose of the law. So, but again, I have not dealt with that directly. And I'm always inclined to encourage you to follow the letter of the law. So, and then finally, will the recording of this webinar be available somewhere? Yes, Liz Tezick will send that out at some time in the next 24 hours. So, thank you again very much for your attention today, and have a happy rest of your day. Thanks so much for listening.